Hello and welcome to this webinar entitled Essential Contract Drafting for the Supply of Goods and Services with me, Keith Markham. Let's have a look at the agenda. So we'll start by talking or reminding ourselves of the different types of contract terms. So we won't take very long on that, but before we proceed to go through the detail, then we do need to remind ourselves what we mean by things like conditions, warranties, and innominate terms. Once we've done that, we will then spend most of the session talking about goods and clauses in a goods contract. So we're going to focus particularly on things like quality, delivery, and acceptance. We'll look at what the law is, and then we will talk about various clauses, which I'll ask you to kind of review, typically from the supplier's perspective, and then we'll think about drafting tips that can apply in each of those cases. So that'll be most of the session on goods. At the end, we will also look at services. So we'll look particularly at issues around the quality of services and think about what the law says, and then look at particular clause and think about what sort of drafting tips we could apply on that occasion as well. When you look at those clauses, effectively, you're welcome to pause the video if you wish to do so. Obviously, I won't be doing so for sake of time. So let's begin then by talking about different types of contract term. Now, we see on the left-hand side, we've got conditions, warranties, and innominate terms. And it's really important when you're looking at a term on the page in front of you to work out which of those three types you've got. So how do we identify them? Well, with a condition, funnily enough, if the clause says this is a condition of the contract, it is likely to be treated as such by the court. But the other phrase to watch out for is if anything is said to be of the essence of the contract. So classically, that tends to be linked up with things like timing. So time for payment is of the essence of the contract. Time for performance is of the essence of the contract. Time for delivery is of the essence of the contract. We're making that clause a condition. We're essentially saying it's a clause of great importance in the context of that contract. Now, a warranty, how do we identify a warranty? Well, pretty easy stuff, really. We have a statement that says, we warrant this or we give a warranty that. So very easy to spot. But how do we spot an innominate term? An innominate, as you can see there, means nameless. It's basically everything else that's neither a condition nor a warranty. So it's quite a large sort of residual category of clauses, which effectively is neither one nor the other. Now, we need to be able to identify them. Why is that? Well, because of the remedies that you see on the right-hand side. So it really does have a profound impact. So in terms of a condition, if a condition is breached, then strictly speaking, the aggrieved party, the innocent party, can terminate the whole contract and claim damages. So, for example, if we think about time for deliveries of the essence of the contract, if somebody is 5 minutes late, the supplier, the customer can terminate the whole contract. That's how significant that is. Now, a warranty, which is much more commonly used, as we will see, essentially there is no right to terminate at all. There is only a right to claim damages at law, albeit usually the person who is given the warranty will offer some form of repair or replacement type approach.